Welcome everyone to the House Committee on Judiciary and Hawaiian Affairs. My name is David Tarnas, I'm chair, and Vice Chair Greg Takayama is here as well, along with members Gregor Iligan and Sam Kong and Kanani Souza. Thank you all representatives for being here. It is Wednesday, February 15th, 2 p.m. Conference room 325 in the state capitol, and we're also running this by video conference. For those who are testifying today, I would request that you keep your testimony to about 2 minutes. Ask you to summarize at that point, just so we can get through all the testifiers who wish to testify on the measures today. If you're testifying via Zoom, please keep yourself muted and your video off until I call you, and then you can turn your video on, unmute yourself, provide your testimony, and then when you're filed, go ahead and turn off your camera and your microphone. If for some reason you get disconnected, just please rejoin and let the tech staff know on the chat function, and then we'll be able to bring you back in as soon as we can and to provide your testimony. If you're testifying via Zoom, please don't have any trademarked or copyrighted images behind you. And for all the testifiers here in person and remotely, please use your best behavior. It's okay to disagree, but let's not be disagreeable. We're all here to do the people's work, and so we're as allies. I appreciate that. What I'd like to do, with everyone's permission, is to take one bill out of order, and that is HB 834. It's the last bill on the agenda relating to American Sign Language. We want to do this because we have an interpreter here to provide ASL interpretation for the bill for testifiers who are here. And so what we're going to do is have the testimony on HB 834, and then we'll do decision making on that one bill. And then we'll go back to the beginning of the agenda from the top. So that's what our plan is, just so everyone knows. So with that in mind, thank you members for being here so that we can have the first bill, HB 834, which we'll have our testimony on, and then we'll go into decision making on that bill only, and then go back to the rest of the agenda. Okay, so on HB 834, relating to American Sign Language, it recognizes American Sign Language as a fully developed, autonomous, natural language with its own grammar, syntax, vocabulary, and cultural heritage. First up, we have testimony and support from William Hoshijo, the Hawaii Civil Rights Commission. And we have testimony and support from Kirby Shaw, State of Hawaii Disability and Communication Access Board, and testimony and support from the Hawaii Disability Rights Center, Lou Erdechek, and testimony in support from Mr. Ed Chevy.
I'm here. Did you want
Please. Yes. Mr. Chevy, please, if you would come on up to the podium here, so that you can be in the view of the camera. And why don't you come right behind me here? Perhaps right over here. Would that work for you? Okay. So, yeah, thank you for being there. And
aloha, aloha. I actually want to say that communication itself is powerful. And having access to communication is critical, because without communication and access, you're communication impaired. So yes, ASL is in fact a full language. There's also, there's a tremendous amount of study that's been done on this. You can never judge people, deaf people, by the language they use, because it is a full and complete language. Without ASL, we are disconnected from communication. And we need be able to have everyone involved, because without citizens who can make our country great, we also have to have access to communication. So thank you so much for supporting this.
Thank you very much. And if you would, please, sir, stay until after all of the testifiers so that if we have questions, we can ask you, if that's okay. Great.
That's fine, thank you so much.
Thank you very much. Why don't you stay here just in case there's others that might. Is Juanita Brown testifying in support? And I guess that's it. Eleanor McDonald, Eileen Chiwa, Lisa Tom, Jan Freed, Fanny Ye, Peter Fritz, and Dana Chiave. Do you want to testify? Oh, okay. Okay. Is there anyone else here wishing to testify on this measure? House Bill 334. Seeing none, questions, members? Any questions? Nope. Nope, no questions? I think we're all okay. Thank you very much, sir. I appreciate your testimony. It's very meaningful. Thank you. Okay, so.
Thank you so much.
Thank you. And you can, if you want to interpret for him while we go into decision making. So we're just going to go right into decision making on this one bill, and I appreciate all the members being here. This is actually really cool that we get to vote on this bill that recognizes American Sign Language as a fully developed, autonomous, natural language with its own grammar, syntax, vocabulary, and cultural heritage. I am totally impressed by anyone who is fluent in ASL. It's just staggering my imagination that one can have that facility. And it enables people who aren't otherwise able to communicate to do so, and we need to do everything we can to help facilitate that and make sure that those people who need to use ASL are able to fully engage with the community and with their government. And so we're very grateful that Mr. Chevy is here today testifying, and if we can do anything to help others like Mr. Chevy testify, we should do that, because this is all part of making our legislature more accessible to the public. I'm happy with the language of this bill as a House Draft 1, and I'd like to move it on to the Consumer Protection and Commerce Committee. My recommendation to the members is to pass this out as is. Any questions, members? No questions or concerns? Representative Ganadin.
Grateful to the testifier for coming here and communicating with us today.
Yes, absolutely, thank you.
A lot of us who watched the Super Bowl saw different forms of sign language, including a Navajo signer. So I hope that this bill
Yes.
in the future can be expanded upon to include other languages that are communicated in the same way as ASL.
Yes, thank you. Also, this will open a whole new world by actually passing this bill, because we've got culture and language that are being recognized here, and that makes us one family.
One more? Yeah. As the Hawaiian language is a co-equal to English under the Hawaii State Constitution, I'm wondering if after we pass this bill, we might consider another one for that language.
Do you know that here we have also a variety of different cultures and languages, and you know, it's that we have different sign languages and different visual languages here, and I think that that's really important. Something about Hawaii, a little bit different than the continent for sure, that we are one family because of how we are represented across different languages and cultures.
Thank you.
Thank you very much.
Thank you, Representative. Any other questions or concerns about this bill voting as is, House Bill 834 HD1? Seeing none, Vice Chair for the vote.
Voting on House Bill 834 HD1 passing as is. Chair and Vice Chair both vote aye. Representative Ganadin. Aye. Representative Holt. Aye. Representative Hashimoto.
Aye.
Representative Ichiyama excused. Representative Iligan.
Aye.
Representative Kong.
Aye.
Representative Mizuno.
Aye.
Representative Souza.
Aye.
Chair, your recommendation is adopted.
Thank you very much. And thank you, Mr. Chase.
Wow, thank you. Thank you so much. Yahoo. Thank you.
Thank you, Mr. Chevy. Okay, so we're going to now go back to the beginning of the agenda, and the members, you may see them leaving because they have, they're tracking other hearings, doing work in their office, but they're monitoring this hearing so that we're going to call them back, and they'll be rejoining us a little bit later. Thank you, Mr. Chevy. Okay, let's go on now to House Bill 1128, relating to support for traditional native speakers of Hawaiian. First up, we have Keith Regan, Department of Accounting and General Services. Welcome. The floor is yours. Please proceed.
Thank you. Representing Comptroller Regan, I am Dr. Adam Jansen. I have the privilege of serving as State Archivist and Administrator of the Public Archives. DAG stands in support of this bill. We submitted testimony, and we appreciate your consideration of our comments from our rather different point of view. Thank you.
Thank you very much. Next, we have testimony from the Department of Education.
Good afternoon, Chair Tarnas, Vice Chair Takayama, and members of the committee. I'm Tammy Chun, Deputy Superintendent for the Department of Education, standing on our comments regarding this bill.
Thank you very much. Next, we have testimony from Office of Hawaiian Affairs. Next, we have, in support, next testimony from Kahea Faria, Kaleo Onakupa. Welcome. Aloha.
Aloha Chair, Vice Chair, and members. I am Kahea Faria. I represent Kaleo Anakupa, a council of native speakers. We stand in strong support of this bill. And I just wanted to say that we did reach out to the Department of Education and also the Charter Schools Commission's office to see if we could respond to any of their concerns. And we continue to be available to respond to any of their questions and our concerns. Mahalo nui.
Mahalo nui. Next, we have testimony from Kauna Leva in support. Testimony from Ka'au Nesmith. Welcome. Ka'au Nesmith.
Mahalo nui to the committees. Thank you very much for having this opportunity for us to support this bill. And we also want to give a special acknowledgement to the accomplishments of our colleagues across the islands in their efforts in revitalizing the Hawaiian language in their way. And we would like to point out, to be specific about who the demographic is that we're talking about. We are talking about here people who are native speakers, meaning have never lost the language at any time. Grandparents, parents to children have never lost the language, which is different than saying those who are going to classrooms to learn Hawaiian because they did lose it at some point. We all wish we were like the native speakers and never had lost it. That's what we all wish for, everyone. And so we want to clarify here that we are talking about two unique demographics that are not to be confused. So the Ni'ihau community are not the Hawaiian Immersion School Project. It is not the same. Should not be regarded as the same, and they have rights that are specific to them. So the Ni'ihau community have a basic human right to their language, meaning public notices in their language, which is not based on the invention of academics, which is unintelligible to native speakers. So that's an aspect of education that we'd like to leave with the committee, is that these two communities do not speak the same language necessarily. And this is why this bill exists. So we want to acknowledge the Ways and Means Chair, Senator De La Cruz, for having the foresight to establish this bill and to work with the Ni'ihau community to develop the language of the original bill. We regret that it had been changed to insert a specification that seems inappropriate. The 500, island of 500 or less, that makes no sense at all. It guts the essence of the entire bill. And it's important to strike that. The other aspect is that we want to acknowledge Representative D. Morikawa, representative of Kauai Ni'ihau, for her adamant support. And as far as the creation of this bill, we want to acknowledge the school Kekula Ni'ihau Kekaha in Kekaha, which was the first to ask how can we seek to guarantee the rights of our Ni'ihau language separate from the efforts of the immersion schools, just ourselves, because we exist as a community, babies to grandparents, as an intact community, the last in the world, which doesn't exist anywhere else. There are native speakers of the other type of Hawaiian, the new type. Yes, there are. Congratulations, and their accomplishments are meant to be congratulated. Because that is a new demographic of Hawaiian speakers that exist and have rights for themselves. Please support those efforts as well. This bill does not infringe on anyone else's right to have language provided in their version of Hawaiian, but for the first time ever, legislation is being introduced to support the rights, the linguistic rights of our Ni'ihau community, to make sure that they have their basic human right to be informed in their language, which is not the language of academics. Thank you very much.
Thank you very much. Mahalo. Next, we have testimony and support from Kailoa Kahale. Next, we have testimony and support from Kahele Cruz. And we have written testimony and support from numerous individuals: Dara Yasushiro, Charles Michael Victorino, Donna Victorino, Leimomi Khan, Ku Aloha Ho'omana Wanui, Miley Kaku, Regina Gregory, Ralph Hasegawa, Donovan Kealoha, Keo Kapukoa, Ka'o Hela Uli'i, Dana Keawe, Donovan Kealoha, Andrew Kahale, and J. Hau'oli Lorenzo El Arco. Is there anyone else here wishing to testify in HB 1128? If not, questions, members? Yes, Representative Ganadin.
To Dr. Nesmith, apologies for making you stand back up and return. Well, thank you for educating the public and the community about this need. On page 5 of the bill, it discusses the translation of public documents, notices, and medical records. Is the Ni'ihau community lacking in services as a result of a failure of the state to translate necessary documents?
Yes. Because there has been stipulation over the past number of years now to have Hawaiian. It didn't specify what Hawaiian, and as a professional translator myself, what I see happening is academics. So these newly invented words that they create among themselves are unintelligible to native speakers, so they're ineffective.
Okay. So basic services, notices, medical records, these things aren't being communicated appropriately?
Not appropriately.
Well, thank you very much. Well, also just a quick one. Just as a matter of curiosity, what are some of the differences? What does it sound like?
Well, since the vast majority of new speakers today are picking it up from classrooms, being English native speakers, they then speak Hawaiian after they pick it up with an English accent. They tend to think in English, and so the words that come out, you can envision them thinking in English because the words are coming out that way. That's one thing. Another thing is I was a member of the lexicon committee back in the 90s, and some of the other members of that committee are also present for the Ahapunanaleo presentation coming up. But as a member, our committee was in charge of creating new words, and the vast majority of those words are unintelligible to native speakers because they're brand new inventions based on English.
Yeah. Yeah. Wow. Well, thank you. This is really amazing work that you're doing.
Thank you.
Thank you. Any other questions, members? If not, thanks very much for the testimony on this measure, and let's move on to the next one. House Bill 1508, relating to Native Hawaiian affairs, appropriating funds to certain departments to provide grants to tax-exempt nonprofit organizations that have experience and expertise in supporting and advancing Native Hawaiian communities. First up, we have the Attorney General.
Chair, Vice Chair, members of the committee, Deputy Attorney General Elise Amemia, the department thanks you for this opportunity to provide comments. Article 7, Section 4 of the Hawaii State Constitution requires that grants be provided pursuant to standards provided by law. Initially, we don't see any standards in this bill, so we have some suggested amendments as a starting point for the committee to work from. I am available to work with the committee and am also available for questions as well. Thank you for this opportunity to testify.
Certainly. Thank you very much for being here and testifying. Next, we have testimony with comments from the Department of Budget and Finance. Next, we have testimony with comments from the Department of Business, Economic Development, and Tourism.
Aloha Chair, Vice Chair, and members of the committee. Mark Ritchie from DBED will stand on our written testimony offering comments.
Thank you very much. Next, we have testimony support from the County Council on Maui, Alice Lee, the Chair. And we have testimony support from Kuhio Lewis, Council for Native Hawaiian Advancement, or his representative.
Aloha, Chair, members of the committee. Sterling Wong for CNHA for Kuhio. We stand on our testimony in strong support. Mahalo nui.
Mahalo, Sterling. Good to see you, sir. Next, we have testimony in opposition from Kenneth Conklin, testimony with comments from Brandy Lynn, Makalani Hayden, testimony and support from Dara Yatsushiro, Juanita Kawamoto Brown, and Dana Keave. Is there anyone else here wishing to testify on HB 1508? See none. Question. Oh, yes, please. Introduce yourself and please proceed.
Omakako, my name is Hema Kealoha Nui Kayama Watson, Honorable Chair David Tarnas, Honorable Vice Chair Greg Takayama, all other members. This is a pretty straightforward proposal. I'm not legal aid, so I can't tell you anything about that. But by supporting our many nonprofits that have service supported and help build up our Hawaiian communities, we are creating a more healthy Hawaii. One nonprofit I have worked with is Paipai'ohe'eia in Kaneohe, and they have in their studious work restored and are continuing to restore a large lokoi'a or fish pond in Kaneohe Bay. This lokoi'a will help grow our marine wildlife populations, give us space for traditional practices and gatherings, and provide hundreds of opportunities for students to learn. My school is somewhere between like 80 to 90% Native Hawaiian, and our 7th graders go there almost every other week to this site. They learn about our aquaculture, about our food system, and all of our cultural practices. If we could support nonprofits like this, it would show that we care, it would show we want them around, and it would also show, it could help them, big or small, expand their reach across all of our Hawaiian communities. Again, I testify in strong support for House Bill 1508, and for all other committee members to do the exact same. Mahalo no, oya.
Mahalo. Anyone else here wishing to testify on HB 1508? Otherwise, questions, members? I have a question for the Attorney General. Thanks for being here. Thank you for your suggested amendments. You know, you gave your one attachment was possible standards for the grants in this bill, but then your other suggestion was possible wording to appropriate funds to the departments for purchase of services.
Correct.
So it's one or the other.
Correct, right.
And so in your, the second one where it's appropriating funds to the departments for purchase of service,
Yes.
if you read through it, it doesn't say that it shall be used for purchase of service. It just says purpose of improving, and just lists it, but do we need to say in here that a POS is what's expected, a purchase of
Uh,
service is what's expected?
No, I don't believe so. I think that this, the wording of the rewritten wording to just appropriate the funds, it's understood that it would be, the department would go out to purchase the service, and it would probably use the RFP process for that.
So it'd be that's what my next question was, the process they would use.
Is the RFP process.
So a competitive bid, or putting
Well,
out for a
proposal.
request for a proposal.
Correct.
And then getting the request, or getting the proposals in, they would judge them and then select one.
Yes, correct.
Okay.
Yeah.
And what criteria would the agencies be using? Would they set their own criteria through, in the RFP? Or how do people know what the criteria is?
Yes, so I think, I believe that, right, the department would, in accordance, with what's the purpose of the bill, and then take those, and the department would have to develop some criteria for the RFP process. I'm not quite sure, but it would be the RFP process would be in accordance with the purpose of the act.
Yes.
Yeah, so,
I just wanted to make sure that whoever is applying knows what the criteria that's being used to judge their proposals.
oh, that would be contained in the RFP.
Okay.
Yeah.
So the RFP itself would have the criteria in there upon which their proposal would be judged?
Yes, the RFP process, generally, it spells out the criteria.
Yes.
It'll lay out the evaluation process. It'll lay out how the proposals would be judged. That's all through the RFP process.
Okay,
Yeah.
okay. I don't want people to be surprised.
Yeah,
I think
it
there's
would-
been some recent experience that has shaken people's confidence in the purchase of service process that
Mm-hmm.
can be, subverted and people can be surprised.
Okay.
So that's what I
Yeah,
was just
generally,
asking.
generally my experience with this RFP process for my client, which is DBED, the RFP would be issued. Contained in the RFP would have all the criteria for how the proposals will be judged, how it's going to be evaluated. There's sometimes a evaluation sheet that may sometimes be a part of the RFP, and that would all be in the RFP.
Okay,
Yep.
okay, thanks. Any other questions, members? Seeing none, thank you very much. Appreciate it. Okay, let's move on to the next measure. House Bill 1430, relating to the University of Hawaii at Hilo, establishes the Institute of Indigenous Education, Science, and Outreach within the University of Hawaii at Hilo. First up, we have Kaiu Kimura in support on Zoom. Aloha.
Kaiu Kimura here on behalf of UH Hilo Chancellor Bonnie Irwin. I just stand on our testimony in support and am available for any questions if you have any. Mahalo.
Kaiu, could you please summarize your testimonies for those who may not have had a chance to read it?
Yeah, so in summary, we are seeking support from the legislature to establish the Institute for Indigenous Education, Science, and Outreach within UH Hilo. This infrastructure, if you will, of an institute will help us further support the efforts that have already been laid forth for Hawaiian medium pathway education throughout the island chain, and to better help serve other communities who are seeking to have support in the area of Hawaiian language resources and Hawaiian medium education.
Thank you.
I also have on the call with me my colleague Kale Raposa, who can also help to address some of the questions as well.
Mahalo. I appreciate if you would be available for questions after we finish the testifiers on this measure. Thank you.
Sure thing.
Mahalo. Okay, next we have testimony support from numerous individuals, totaling 91 testimony in support. We have a couple that might be here in person or on Zoom. Juanita Kawamoto Brown in support. John Patu. Let's see, anyone else indicating they were going to be here? No. So is there anyone else here wishing to testify on HB 1430? Seeing none, questions, members? Yes, Representative Souza, please proceed.
Oh, Kaiu, thank you for being available for questions. I just wanted to know if you could kind of explain more of like the science component and how that fits into the Hawaiian language component. Just from the bill and just from the vagueness of the bill, it just sounds like we're sticking a Hawaiian Language Institute at the Imi Ola Astronomy Center. So can you try to bridge the gap for me? Thank you.
Yeah, no, excellent question, Hikino. Yeah, the title is a little confusing, a lot. But science as it relates to Imiloa's mission, really founded upon the intent to bring together a Hawaiian worldview, culture, values, language, with modern research being done here in Hawaii. Starting, with astronomy, but Imiloa has really diversified to cover many of the different scientific endeavors being done in Hawaii, from bottom of the ocean to the outer edges of the universe. So that work that Imiloa has done in partnership with the College of Hawaiian Language to expand the use of Hawaiian language in the domain of science, as well as to help further build out the relationship, the connectivity, and the relevance of scientific work being done in Hawaii to our local communities, and particularly to be experienced through both Hawaiian language and English, has sort of been the major focus of Imiloa. And Imiloa has been, it is a result of a partnership with the College of Hawaiian Language during the formational years of the center. So the college directly got involved and engaged in the building of Imiloa, specifically for the intent of building out more spaces and places where Hawaiian language is used, and is helping to influence the work being done as well as it relates to science. So under the Institute, both the college and Imiloa would sit, both having their unique purpose and services to the audiences that they serve, but collectively together under the establishment of the Institute, could work in stronger collaboration to support the development of more Hawaiian language resources being created and distributed statewide.
Thank you.
Mahalo. Any other questions, members? No, thank you very much. Mahalo to you for your great work, and to your colleagues there at UH-Hilo. Mahalo.
Vikino, mahalo nui.
Okay, let's move on. Next, we have House Bill 1157, relating to the Office of Information Practices, allows the Office of Information Practices to issue written guidance to resolve disputes under the state's Uniform Information Practices Act and Sunshine Law. Appropriates funds for 2 new permanent positions in the Office of Information Practices. First up, we have Ms. Cheryl Park, Office of Information Practices. Welcome. The floor is yours. Please proceed.
Aloha, members and
Aloha.
Chair. I'm Cheryl Kakazu Park, the Director of OIP, and we stand in full support of this bill. It's based on an amendment to a bill last year that was proposed by the League of Women Voters, and the substantive provisions are the same in other bills that are pending before the legislature this year. Somehow this bill got changed, the structure of it, and we would actually prefer the language or structure that was found in Senate Bill 719, which we don't know if it's going to pass out of the Senate yet because they haven't had their hearing yet. But we do, the substance of both bills are the same. And we are in full support of this because it would amend the UIPA so that when OIP concludes in written guidance that agencies or boards have complied with the UIPA or the Sunshine Law, and an opinion isn't needed to obtain their compliance. And so OIP would have the discretion to not issue a formal opinion in that case, which takes us a lot of extra time that we could use doing something else. So this is the language that the League and OIP have agreed upon, and it gives us the legal authority, which we don't have now, to do what the bill proposes us to do. It's consistent with what the Civil Beat Law Center even suggested on its website that we do, and what a House concurrent resolution in 2019 suggested that we do. But now we need the legal authority to actually provide written guidance instead of opinions. The other part of this bill is very necessary, whether this bill is passed or not, because we need 2 additional positions and funding for that. OIP's work has been increasing over time. Back in 1994, we had twice as many positions, 15 positions compared to 8.5 that we have currently. And we only did the UIPA back in 1994, 29 years ago. And we have the Sunshine Law as well. So we have twice as much work, half the staff. Our funding back then was more than we had last year. 29 years ago, our allocation was $827,000. Last year, our allocation was $752,000. If we had what we had in 1994, the equivalent in inflation-adjusted dollars would be 1.6 million today. So thank you for considering this.
Thank you. Appreciate your testimony. Next, we have testimony in opposition from Civil Beat Law Center for the Public Interest, Brian Black. Next, testimony in support from League of Women Voters of Hawaii. Next, testimony in opposition from the Hawaii Chapter Society of Professional Journalists. Next, testimony in support from Juanita Kawamoto Brown. And testimony in opposition from Andrew Crossland and from Corin Solomon. Testimony in support from Lynn Matasau. And testimony in opposition from Keikilani Ho and Scott Shedko. Is there anyone else here wishing to testify on 1157? If not, questions, members? I have a question for OIP. Ms. Park. So you would actually prefer Senate Bill 719?
Yeah, the structure is better there. It's less confusing. They split up the definitions in different parts of this bill. We'd prefer how it was in 719. The substantive provisions are the same.
Yeah. Okay.
Thank
Okay,
you.
thank you. Any other questions? If not, we'll move on. Thanks very much. We're on to House Bill 1037. This is relating to statewide interoperable public safety communications. Reflects the migration of the Office of Homeland Security from the Department of Defense to the Department of Law Enforcement on January 1st, 2024. First up, we have Ken Hara, or his spokesperson from the Department of Defense.
Good afternoon, Chair Tarnas, Vice Chair Takayama, and members of the committee. This is Everett Kanishige. I am the statewide interoperable communications coordinator with the Department of Defense. Major General Hara apologizes, but he's not able to attend today's hearing, so I'll be representing him and myself with respect to the written testimony that we submitted. We will stand on our written testimony, and I'll be available to answer any questions by the committee. Thank you.
Thank you. Next, we have testimony and support from the Department of Law Enforcement and testimony and support from Juanita Kawamoto Brown. Anyone else here wishing to testify on HB 1037? If not, questions, members? Seeing none, we'll move on. Thank you. Next, House Bill 1385, relating to public lands. Authorizes the designation of areas or regions of public lands classified as commercial and industrial, hotel, apartment and motel, or resort, and the establishment and implementation of guidelines for the redevelopment of the areas or regions. And then it goes on, and this designates the public lands on the Waiakea Peninsula on the island of Hawaii as the Waiakea Peninsula Redevelopment District. There's other things in the summary which I won't read, but we will learn about it in testimony. 1385. First up, we have testimony in opposition from the Department of Land and Natural Resources. Welcome. The floor is yours.
Thank you. Good afternoon, Chair, Vice Chair, Committee Member. Kevin Moore with the DLNR Land Division. The department will stand on its written testimony in opposition, and we're available for questions.
Could you please summarize your testimony, if you would?
Sure. We don't think that a new planning authority is needed or helpful on Waiakea Peninsula. The DLNR does manage those lands. We have about 6 leases and permits there right now. The 2 major hotels are the Hilo Hawaiian and the Grand Naniloa Hotel. We have the former Uncle Billy's, which is shut down. It's slated for demolition. We did receive an appropriation last year, but the appropriation was designated to come out of our own Special Land and Development Fund, which doesn't have enough funds to cover the $13.5 million to bring it down. So we're coming back to the ledge this year, hopefully through a governor's message to change the funding to general funds to do that. The country club is under an RFP right now. We're close to making a recommendation to the land board to select a developer for a new long-term lease of that property, which will include major renovations to it, continue its operation as a hotel and apartment. And then we have a couple of the properties there. One is on a month-to-month permit. That's Reed's Bay for a hotel operation. We have Banyan Bayview, which is a long-term lease with a few more, 12 more years or so to run. And I understand they may be approaching us with an application for a lease extension. The golf course area is part of the Naniloa Hotel, so there's been talk about taking the golf course area out of the lease and trying to do something different with it. That would require cooperation of the lessee, and that lessee is in foreclosure right now, which makes it a little bit difficult.
Okay. Thank you, Mr. Moore. Next, we have testimony from the Department of Budget and Finance, Office of Hawaiian Affairs, testimony in opposition from the League of Women Voters, testimony in opposition from Kupuna for the Mo'opuna, testimony in support from Juanita Kawamoto Brown, testimony in opposition from Will Karen and Dana Keave. Is there anyone else wishing to testify on 1385? If not, questions, members? I have one question.
Mr. Chairman.
Yes. Go ahead. Introduce yourself, please. Oh, he's stuck again. We're not able to hear you. You're frozen. You're frozen. We can't hear you, and your video is frozen. So try again. Maybe turn off your video and just try speaking.
Turn off the video.
I'm sorry, Mr. Rohrig, it's not working. Okay, your video's off. Now, Mr. Rohrig, why don't you go ahead and try talking and see if it works. No sound. We don't hear you. Unmute yourself.
Excuse me?
Ah, there you are. Please, I hear you now, so please proceed, Stanley. Mr. Rohrig, I'm sorry, we don't hear you either. It was a good try. If you could submit written testimony, or you did already. We have your written testimony, members. You can take a look at it. He's testified in support. And we're not able to hear you, Mr. Rohrig, so we're going to need to move on.
Okay. I'm sorry you can't hear me, Mr. Chairman.
Okay, thank you very much, Mr. Rohrig.
All right.
Okay, actually, Mr. Rohrig, I think we can start hearing you now. Do you want to try one more time?
I'll try one more time.
Okay, go ahead. Please proceed.
I was on the land board for 5 years as a representative from the Big Island. And during this period of time, the problems reflected in this House Bill 1385 became rather obvious to me as a member of the land board. The definition of the Waikea Peninsula would suggest to me as a resident here that this bill doesn't just include Banyan Drive, it includes all of Hilo, because most of the industrial lots in the airport are within the Waikea Peninsula, not just the Banyan Drive. The suggestion that this is only seven different projects is not accurate based on the definition of the scope of the bill. And because of the problems that we've had historically in this area, the the community and the legislators from this area got together, and I believe that they have substantial involvement in the creation of this measure, and it should not be put on the shelf this early in the session. This matter should be given further examination by the House and the Senate, because of the fact that this is a reasonable solution for the problem. It's not an unreasonable solution. I have read through the bill. There seems to be areas that we need to have better definition, but the fundamental idea is sound. And it should not be put aside by one of the departments that has a vital role in the historical context of the problem.
Thank you, Mr. Rohrig. Would you like to summarize, please?
I suggest that you pass this bill and you can consider hearing it in the House Finance Committee, and you give the opportunity to the members of the House and the Senate to conference on this matter, because this is the heart of Hilo's development right here, this bill, one bill.
Thank you very much, Mr. Rohrig. I'm so glad that we were able to hear your testimony, and we're going to proceed, and if we have questions, I'll ask you to come back again. Mahalo.
Thank you very much, Mr. Chairman and committee members.
Okay, is there anyone else here wishing to testify on HB 1385? Seeing none, questions, members? Mr. Moore, just a quick question. Could you please explain what you what you include in your testimony regarding your current work with HCDA? You said you're looking to work with Hawaii Community Development Authority to develop a master plan and infrastructure assessment for the Waiakea Peninsula. Could you describe what that scope is and your timing for that?
Sure. So there's another bill this session, I think it's a Senate bill, that would turn over the Banyan Drive, Waiakea Peninsula area to HCDA. And HCDA had some concerns about that. So we've been talking to them at the department head level, trying to figure out how we could collaborate and address the concerns of, the concerns that lead to the introduction of bills like these. And so we've had some initial talks, and I think we're having a meeting tomorrow to try to pin down what they can do to help study infrastructure and propose development plans and things like that.
Good. I mean, HCDA might have some useful role with you in managing this, and that's what you're exploring.
Right.
Okay. All right. Thank you. Okay. Any other questions, members? If not, thanks very much, Mr. Moore.
Thank you.
Let's move on to the next measure. Thank you, Mr. Rohrig.
Thank you, Mr. Chairman.
Okay, let's move on to the next bill, HB 921, relating to environmental crimes. Establishes the Environmental Crimes Unit within Department of Attorney General, makes the disposal of motor vehicle tires in violation of state law governing recovery of used motor vehicle tire recovery a petty misdemeanor. Establishes a $1 motor vehicle tire surcharge for every replacement tire. Requires tire retailers and wholesalers who install replacement tires to pay the surcharge to DOH. DOH has to deposit this into the Environmental Management Special Fund, and it allows DOH to use the Environmental Management Special Fund to fund the Environmental Crimes Unit. 921. So we have testimony first from the Attorney General.
Good afternoon. Sorry. Good afternoon. Good afternoon. Good afternoon. I'm sorry.
I'll come back to you, Mr. Young. We're going to go first. You stay right there. We'll come back in just a couple minutes, so get a glass of water. First, we'll go to the Department of Health, testifying with comments. Please proceed.
Good afternoon, Chair Tarnas, Vice Chair Takayama, Lene Ichinotsubo with the Department of Health and Solid and Hazardous Waste Branch. The department stands on our written testimony providing comments. Thank you.
I'm going to ask you if you would summarize your comments so that the members of the public will understand.
Sure. First, with regards to the establishment of the Environmental Crimes Unit, we defer to the AG's office for their comments. We offer some language for Section 22 to offer clarification so that we can ensure that the administrative enforcement is still applicable and the penalties associated with that within this section. It's in this section of the chapter. And in addition, we just wanted to note that to the committee how much money we collected when we had a surcharge in past years with regards to the importation of tires. We recognize that this bill talks about the replacement of tires, so we anticipate that the amount of funds that comes in will be somewhat less than that threshold. And then finally, in order for us to implement this and the management of the accounts, collecting the funds and whatnot, we are asking for 1 FTE to do that work.
Okay.
Thank you.
Thank you very much. Mr. Young, are you able to give us your testimony now?
I hope so. I hope so, Chair.
Okay, please proceed.
Good afternoon, Chair Tarnas, Vice Chair, members of the committee. We did submit comments. They are mainly housekeeping comments. We did have a question regarding the single purpose of the bill and the fact that the establishment of the tire surcharge may exceed relating to environmental crimes. Our other comments were mainly regarding how the funds to environmental unit would be distributed. But I stand ready to answer any questions. But really, we just had housekeeping concerns.
Okay, thank you.
And I'm sorry for my voice.
No, I hope you get better soon. Thank you very much for your testimony. Members, I would refer you to the testimony from the Department of Attorney General. They do have some substantial comments in here, concerns about how the bill is crafted and how there's still lots of questions about the bill. Next, I'd like to ask the Makaha Hawaiian Civic Club, or representative wishing to testify? If not, next we have testimony from Malama Makua, testimony from Librado Kobian, testimony with comments from Melissa Pavlicek, Hawaii Automobile Dealers Association, testimony and support from Juanita Kawamoto Brown, and testimony with support from Ruth Love. Is there anyone else here wishing to testify on House Bill 921? Seeing none, questions, members? No? Representative Khan, looks like you're ready to ask a question.
Department of Health, I'm not sure if you're the one to ask this question to, but I will. Is there not already a surcharge applied when we replace a tire or do anything with a tire?
Okay, so with regards to a surcharge,
If you could please bring the microphone right next to you.
with regards to a surcharge, years past, there was a surcharge collected $1 for every tire that was imported into the state. That has sunsetted some years back, so there is no continued surcharge being collected on that. However, there is a charge that retailers do impose for the disposal of the tire, but that funds does not come to the state. It is for their use to actually do the proper disposal of the tire.
Oh, now it makes sense.
Okay.
Okay, I thought it went to the state. Because when we collect, so if I was to collect a tire, we clean up the community, and I take it to a tire dealership, they actually charge me for returning. Is that like normal practice?
So the law under 342I specifies that the tire retailer is to accept a used tire when a new tire is purchased. So when you go take your car in and you want to replace your tires, they charge you for the 4 tires that you're getting rid of, I guess, when you buy the 4 replacement tires. And that charge is for the disposal of those 4 tires. Is that?
Interesting. No,
Okay.
it makes sense.
Okay.
Now I know. Thank you very much.
You're welcome.
Okay. Any other questions, members? If not, thank you very much. We'll move on. House Bill 277 relating to motor vehicle insurance. And we have testimony in opposition from the Office of the Public Defender. Welcome. The floor is yours. Please proceed.
Good afternoon, Chair Tarnas and Vice Chair Takayama. I'm here on behalf of James Tabe, who's the public defender. My name is William Bento. I'm a deputy public defender. We do respectfully oppose HB 277 because it seeks to increase the fines for driving without no-fault insurance. As a young attorney, 35 years ago, I used to practice in the district court where the fines were thousands of dollars for driving without insurance like we have. The changes to the law that's cited in Mr. Tabe's testimony helped a great deal, and that's the current state of the law. We feel that an increase at this time really is akin to raising prices in another way, understanding that it wouldn't take effect unless somebody violated the law, of course, but it would in fact increase for those families the cost of living. And so we feel that it's not broken as it is right now. And so we think that it should remain the same and not be increased. Thank you. I'm available for questions as well.
Thank you, sir. Next, we have testimony support from Juanita Kawamoto Brown, testimony in opposition from Dana Kiave, and testimony with comments from Ruth Love. Is there anyone else here wishing to testify on House Bill 277? Seeing none, questions, members? Representative Ganadin.
To Mr. Tabe, Mr. Bento from...
William Bento.
Yeah, William Bento from the Office of the Public Defender. Let's see, can you explain to the committee what happens when an individual is charged with not having no-fault insurance on their person? And then I practice in district court, so I'm just trying to lay out like how it actually happens, and then they come back in and sometimes they have to comply. Like how does it play out?
Well, there's many different scenarios, but let's say the person is pulled over by the police and they don't have a card with them, but in fact they are insured. So they're usually issued a citation for not having the card, go to district court, or I think at this point, because it's civil in nature, and I haven't practiced there for a while, but civil in nature, they can demonstrate that they were in fact insured. If they are not insured, then it's a civil fine. And again, as Mr. Tabe said in his testimony, you go through a procedure of either paying the fine or it going to collection. It's the subsequent or the second one that becomes a petty misdemeanor, and the fines are increased greatly. And the real bad part about that, and I think that's why it was decriminalized to begin with, is that if you don't show up in court or you miss a proof of compliance date, bench warrant gets issued. And bench warrants usually are served at the most inappropriate time. And so if it's Friday afternoon and you can't post bail, you're not seeing the judge until Monday.
So, assuming you practice here in the First Circuit, how many of your clients, per year have to be incarcerated because they are serving a bench warrant or not having an insurance card?
I don't have those numbers, but I can tell you it does happen. Yeah.
Thank you so much.
Thank you.
Thank you, Representative. Any other questions, members? If not, we'll move on. Thank you. Next, we have House Bill 824 relating to medical release. Creates a medical release program within the Department of Public Safety for certain ill, disabled, or impaired inmates who pose a low risk to public safety. First up, we have testimony from the Department of Public Safety. Welcome. The floor is yours. Please proceed.
Thank you. Good afternoon, Chair, Vice Chair, members of the committee. My name is Gavin Takinaka. I'm the Corrections Healthcare Administrator for the department, standing in for Tommy Johnson. This measure is about proposing to codify in statute a medical release program to replace the already existing program we have in our department that currently exists in our policies as well as the administrative rules. We provide comment on this measure, and if I may, I would like to point out some of the modifications that we are requesting, because this personally is important to me. I've been directly involved in this program for the last 4 years, and it is an effective program, and I want to make sure that the language going in, if this goes through, does not derail our current system and put in roadblocks to the current process. So first of all, page 4, section B, we are requesting that it be amended to ensure that the director, an inmate, or the inmate's representative requests medical release when the recommendation is accompanied by a physician, the physician's recommendation. So even the director currently, the director doesn't just request a medical release. It's a process where the physician identifies that the person meets the criteria for medical release because it's a medical issue, and then makes the recommendation. We also work with the community as well. If the inmate's representative wants independent evaluation performed, our policies allow for that to happen. The next area that I wanted to point out has to do with the request or the requirement that the director appoint an advocate for the inmate. So this is page 5, section G, and it brings up the issue of requiring an advocate when there's a question of capacity. As you are aware, mental incapacity, it's not, it's more of a legal issue, legal matter. It's not something that an advocate can take over and make decisions for an inmate. This goes through usually a family court process where a guardian might be appointed or guardian ad litem. I don't want this part of the measure involved in this. We are advocates for the inmates. Once the question of medical release comes up, we are advocating to get the inmate out of our system and into the community. Creating this, and we've had situations in the past where, say a public defender will raise the issue of capacity, that will delay the process because it has to go through family court. So this actually serves as a barrier to the process. The final thing I wanted to bring up was there's a section here on page 6, subsection H, which talks about a fast-track procedure. We fast-track everyone who, where the issue of medical release is raised already. So this subsection is pretty meaningless. It doesn't address the real problem, which is placement in the community. We've had people, and I have the stats, who are still stuck in our system because we can't find placement in the community. Nobody will take them.
Yeah.
Thank you very much.
Thank you. And just for members, the rest of the testimony also includes outlining the number of positions, 2 FTE staffing requirement estimated at $368,996 each year recurring, one physician and 1 advanced practice registered nurse to implement this. Okay, next we have testimony with comments from the Hawaii Paroling Authority. Welcome, sir.
Hi. Law Chair, Vice Chair, committee members. The Hawaii Paroling Authority stands on this written testimony with comments. And if I may just elaborate a little bit on the process that Dr. Takinaka had spoke to you about. So the fast track process is when an inmate has, this was previously known as compassionate release. And the term had been changed to medical release because basically it comes down to a clinical diagnosis for the particular inmate. So if healthcare deems that this person is terminally ill, has a short period to live, or services cannot be rendered within the facility, they can fast track it with recommendations and clinical findings to the Director of Public Safety, who in turn submits it to the Hawaii Paroling Authority for release in the community. So if the person has not hit their minimum sentence yet, the board can convene and look at a reduction of minimum and then schedule it for parole hearing. The challenge is, as Dr. Takinaka was relating to, is that when you have sex offenders or you have those who may require dialysis or who are non-citizens, they're the most difficult to place. And I think Bob Morris, Kat Brady, they all understand the challenges of placement. So they would remain in the facility until we can get them placed in the community. So I'm available for questions if you have any.
Thank you very much, sir. Next, we have testimony and support from the Hawaii Correctional System Oversight Commission.
Martha Torney, I'm one of the commissioners, and we do support this measure, and I'm hearing testimony from the department about how the program currently operates in the department. I would ask them to back that up with some statistics as to how many people actually get released. I understand the problem finding placement. I used to work for the department. But right now in the department, we have approximately 166 inmates who are 65 years and older, which in inmate terms is being an elderly inmate. In the past 2 months alone, 3 elderly inmates have died in custody. One was 73, one was 87, and one was 74. All of them were at the infirmary at Halava. I think we need to start being more aggressive in finding out how we can find appropriate placements before we need them, so we can see where we place these inmates. And it still is a compassionate release program. Nationwide is not just based on medical need, it is based on whether it's the right thing to do, the humane thing to do for the person who is dying. Thank you.
Thank you very much. Next, we have testimony and support from the Community Alliance on Prisons. Kat Brady, welcome. Please proceed.
Aloha, Chair, Vice Chair, and members of the committee. Too many people are dying alone in prison when they actually could have been home with their families or receiving care in the community. There was just research that came out in 2018 from the Families Against Mandatory Minimums, and they did a survey of all the states. There's only one state that doesn't have compassionate release, and that's Iowa. We really believe this is important. The state population, prison population of the states has increased 55% in the last 20 years. That's people who are 55 years or older. They increased 400%. So we believe that in the report of the 49 states that do have programs, only Colorado, Rhode Island, and Illinois actually got an A, and then DC and Massachusetts got an A-. Hawaii received an F. We really believe that it is so important, and we like the term compassionate. And several years ago, several parole chairs prior approached me and said, please don't call it compassionate. And I said, well, when you see somebody who's terminally ill and dying, and his family wants them to come home, we need a bit of compassion to make that happen. So we really urge the committee to pass this measure and make sure that the criteria is absolutely understood by the person, increases eligibility criteria, ensures that eligibility criteria is fair and just, and establishes deadlines to keep the process moving. It provides assistance with post-release planning, and we do understand that there are problems trying to place people who have committed certain crimes. We really want the department, the HPA, to help us. They got money last year for reentry, and we would like to see that they can place people. Thank you.
Thank you very much. Next, we have testimony and support from Juanita Kawamoto Brown. Testimony and support from Will Karen, from Robert Merce and testimony in opposition from Ruth Love. Is there anyone else here wishing to testify on HB 824? If not, questions, members? Representative Ganadin, please proceed.
To the Oversight Commission with Ms. Torney.
Could bring that microphone.
Sorry. The attorney Robert Merce isn't present, but can you explain to the committee the difference between this bill and the bill that was actually passed out of the legislature a few years ago regarding compassionate release?
I'm sorry, I can't.
Okay.
I wasn't here a couple of years ago. I was enjoying my retirement.
Okay. Perhaps maybe the Department of Public Safety could assist me, because we're coming back at this. This was actually a version of compassionate release was passed by the legislature, and I'm trying to figure out what's different this year. Go ahead.
Fred is a little bit more familiar with this than I am, but essentially the measure that came out this year was similar to the one a few years back. There's been some modifications in this HD1, but which gets there, but not quite there. And the requests that we had made in terms of the modifications are important to ensuring that we have an expeditious process. I do have statistics that Martha asked about, if you would like them.
Is that all right, Chair? Yes, please.
So for the last 3 years, in 2020, we had 22 medical release requests. 7 of them are still incarcerated. This is in 2020 because we can't find placement for them. 12 of them have been released, and 3 of them passed away. 2021 and 2022, we had 5. In 2021, none of them are currently incarcerated. 2 were released, and 3 passed away. 2022, 1 is still incarcerated, 1 released, and 3 passed away. The inmates who are being brought up as having recently passed away, those are inmates who have been waiting to be released.
All right. Earlier in a combined health committee, we heard about a program for veterans and houseless veterans. And then there's a variety of other housing programs that the state is going to be embarking on in the next few years. Is there prospective collaboration that the department could engage with in placing these inmates? Should we amend the bill? My question is, should we amend the bill to encourage that kind of collaboration?
I'm going to defer that to our reentry folks, but they are not here today. I'm sorry, I can't speak to that.
Okay, thank you.
Thank you. Vice Chair Takayama, please proceed.
Yeah, Doctor, while you're still up there, in the testimony from Public Safety, you make a strong point of objecting to the addition of requests coming from inmates' representatives. I assume a representative of an inmate would be a family member or a spouse or a loved one. And you say that adding these people would create unneeded and unnecessary delays. I don't quite understand that, because it seems to me that regardless of where the request comes from, first thing you do is maybe go look at the inmate and see if there's any substantial support for such an application. So why would it be such a why would it be such a problem to have these requests come from outside the facility?
Great question. Thank you, Vice Chair. I just had an informal conversation with someone who mentioned that an inmate had just brought up an issue in a parole hearing, trying to go for medical release on a matter that's, I would say, more of a non-qualifying type of condition. we are asking that the requests include a physician recommendation, only because if we get all of these requests from the inmates or the inmate's family directly, or the inmate's representative, our physicians will, we're very sensitive to that. If there is a situation that we may not be aware of because there is some sort of unexpected or change in a person's condition, we'll attend to that right away. To see a potential increase in that surfacing at our facilities might lead our physicians to abandon their regularly scheduled clinics involving chronic care, sick calls, the day-to-day stuff that they're required to see, but are currently, overburdened with at the least at the moment.
I
So
understand,
prioritizing.
yeah.
I'm sorry. Go ahead.
I understand that the demands on a physician's time, but your own statistics show that last year and the year before, you had a total of 5 applications in each of those years, and it seems to me that out of an inmate population of 2,000 or so in Hawaii, that doesn't seem like very much.
I think because of the previous year, our requests caught mostly everyone who was on our radar. We have monthly meetings about potential cases. Currently, we're monitoring 8 individuals who may eventually qualify for the medical release program, but currently does not. So it's a continual process.
Okay, thank you. Thank you, Doctor. Thank you, Chair.
Thank you, Vice Chair. Any other questions, members? If not, thank you very much, sir. Okay, let's move on to the next measure, House Bill 1133, relating to public safety. It requires and appropriates monies for the provision of free voice communication services in the state's youth and adult correctional facilities. Prohibits state agencies from deriving revenue or financial benefits from the provision of communication services to persons confined in state correctional facilities, and it appropriates funds. First up, we have testimony in opposition from the Department of Public Safety. Welcome. Please introduce yourself. The floor is yours. Please proceed.
Aloha, everybody. My name is Shari Kimoto, and I'm with the Department of Public Safety, and I oversee the Corrections Programs and Services Division. On behalf of Tommy Johnson, who had a family emergency, I'm here to quickly summarize our opposition to HB 1133. So I wanted to make sure to clarify that the inmate phone system is not the same as a residential or cellular service. This system monitors and records inmates' personal calls for the safety and security of the facilities and the community. Through this system, PSD has identified many court-ordered violations and criminal activity, and I am the POC that receives these subpoenas to copy phone calls for court. I have to testify in trial on behalf of the phone system. And in fact, in the last year, I've probably received 75 or more subpoenas for copies of inmate phone calls from our system. In the last 3 days, I've received 5 subpoenas for copies of these phone calls. This bill stops PSD from receiving commissions to fund its SAVIN victim notification system and requires PSD to provide free calls for free inmate calls. There is no cost to the state or public safety right now to maintain and operate this inmate phone system. However, we do strongly agree that communication between loved ones and offenders are very vital to an inmate's successful reentry. However, if this bill is passed, PSD is unable to receive commissions, and state general funds may or may not be available to replace the cost of the inmate phone calls and maintaining the system, we will be forced to shut down the inmate phone system entirely, leaving the only form of communication between offenders and their loved ones writing letters and visitation if we have staff available. So we respectfully ask that this bill be deferred, and I'm here to answer any questions.
Thank you very much. Next, we have testimony from the Hawaii Correctional System Oversight Commission. Martha Torney, please proceed.
The commission supports this measure very much. We believe that maintaining meaningful contact with families and significant others is essential to successful reentry for people who are exiting prison. We also want to bring to your attention that this problem of how much inmates are charged is a problem nationwide, and it was so important that the Federal Communications Commission were able to make some rules governing interstate phone calls. And in that ruling, they said the agency is working to rein in the excess rates and egregious fees on phone calls paid by some of society's most vulnerable people, families trying to stay in touch with the loved ones. I want to remind you, it's primarily the families that are paying for these services. We agree with Shari that we need to have services that will allow for recording, will allow for phone calls not to go to certain numbers, not to be forwarded to other numbers, and that should be funded by the state to make sure that that happens. We do want to bring to your attention, though, that when this bill was heard before, people were very concerned about the victim notification system, SAVN. House Draft 1 also includes an appropriation to have the SAVN paid for by state funds. Currently, it is paid for by the State Commission on Inmate Phone Calls. That means the families are paying for it. And we want to say we strongly support the SAVN system. We just don't support the method of funding for it right now, and we urge that you consider having the general funds pay for the SAVN system. Thank you.
Thank you very much. Next testimony, comments from the Office of Youth Services. Next testimony in opposition from the Hawaii State Coalition Against Domestic Violence. Welcome, please proceed.
Aloha Chair, Vice Chair, and committee members. I'm Angelina Mercado, the Executive Director of the Hawaii State Coalition Against Domestic Violence. And on behalf of our 28-member program statewide, we oppose this measure. What this measure does is to eliminate the funding source for our SAVN system. And our SAVN system is a statewide automated victim notification system. And our victims are required by our statute to be notified of various things. So what they're notified about? Parole hearings. Their right to engage in that process for parole hearings. What are they notified about? Their right to know when their offender is leaving the system. If they are not notified, how can we protect our victims? Are we forgetting our victims in this statute? Are we leaving it up to the budget, the general fund, to fund our victim services? We know that our laws to criminalize are not merely enough. We have victims in our community who are afraid for their lives, who are feeling stress, trauma from the idea of having their offender released. If we are going to fund this through the general fund, then we're asking that at minimum there is a proviso to make sure that this is somehow ring-fenced and protected. Thank you for this opportunity to testify. Of course, available for any questions.
Thank you very much. Next, we have testimony in opposition from the Kapiolani, the Sex Abuse Treatment Center. Welcome.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Lynn Costales, and I am the Executive Director of the Sex Abuse Treatment Center. We also oppose this bill for similar reasons as set forth by my colleague over at the Coalition on Domestic Violence. Our concern really is about SAVN and making sure that that program remains intact so that sex assault survivors and sex trafficking survivors are given adequate notice when their offender is being released from a facility. That is vital to their safety, to their own personal safety, as well as to their loved ones. The other thing that I did want to mention, and I kind of stated this in my written testimony, is with respect to any kind of telephonic system that gets implemented within the public safety department, within these facilities, that it, we don't know much about it at this point, what it's going to look like if this all takes place and it's not funded. And I think those were some of the concerns that Ms. Sherry from Department of Public Safety mentioned. But I think what people need to know is that the Sex Abuse Treatment Center is a 24-hour hotline. We run a 24-hour hotline that is accessible to all the prison facilities. So we need some kind of measure in place regarding the safeguards of that system, because in all honesty, sometimes it is misused by many inmates to call the hotline at different times, and it's inappropriate. And so we work closely with the public safety officials to help monitor some of those inappropriate calls. So that being said, we oppose this particular bill, and I thank you for the time.
Thank you very much. Next, we have testimony in opposition from the Sovereign Governance Committee. Testimony in support from Bianca Tylik.
Hello.
Please proceed.
Hi, thank you so much. Hi, my name is Bianca Tylik. Appreciate the opportunity to testify today. I'm the executive director of Worth Rises. We're a national organization that works to end the exploitation of people who are incarcerated and their loved one. I also come here because I understand the concerns that have been raised. I am myself a domestic violence survivor, a rape and sexual assault survivor, and my partner was also murdered. So I come here really as somebody who has suffered victimization quite a bit, in strong support of House Bill 1133. This particular legislation is not new in Hawaii. I understand that there are concerns about how it will be implemented. It has been fully implemented successfully with support from law enforcement and officers in Connecticut and California. The entire prison system of California implemented this in less than 3 months, fully free communication. I want to reassure all those who are concerned about victimization that all of the same security and surveillance features that were part of the system prior to phone calls being free continue to be part of that system in every single state. So that is not a concern. We understand right now families are paying more than $1 million every year. In fact, far more than that, to communicate with their loved ones. We believe it will cost the state actually less than $500,000 to provide completely free calls. And we do completely understand the concern around Savin and believe that anything that these calls are currently funding should be funded by the general fund. We understand from DPS that is roughly $300,000 to $400,000 for Savin. Lastly, just want to share that we do suggest a few amendments to the legislation, particularly to include other forms of communication, including video and electronic monitoring, not electronic monitoring, electronic messaging or emails, which together would come in at roughly $300,000. And we also really urge the commission to consider those 1,000 roughly people who are being held in Arizona in contracted facilities that are actually being charged even more for their calls. And lastly, I just want to remember that there are women who are incarcerated in Hawaii. Over 80% of incarcerated women are victims of sexual assault, sex trafficking, and other matters, and so they too deserve to be supported by victims' rights organizations. So I thank you for your time and just say that this policy has been incredibly successful in reducing tensions, violence inside, and improving reentry and recidivism outcomes outside, which actually means less crime and less victims in the future. Thank you.
Thank you very much. Next, we have testimony and support from Lauren Walker, Hawaii Friends of Restorative Justice. Testimony and support from Linda Rich, Women's Prison Project. Testimony and support from Juanita Kawamoto Brown. Testimony and support from Will Curran. Testimony in opposition from Toby Wilson. Testimony and support from Diana Bethel. And testimony and support from Nancy Youngren. Is there anyone else here wishing to testify on HB 1133? Please come on up and introduce yourself.
Aloha and thank you, Chair Tarnas and Vice Chair Takayama. I'm Dennis Dunn. I'm the retired director of the Victim Witness COCOA Services in the Prosecutor's Office. I recently retired after 44 years of working with victims. During that time period, I often manually handled calls when the public safety would contact me at any time of day or night and call me, and I would call victims. So I can tell you from my personal experience how critically important it is for them. I'll just summarize. This measure would eliminate a critical funding source. If we don't have a dedicated source for Savin, and we don't have some way of assuring that Savin will be available to victims, all of the people who've signed up for and appreciate and benefit from this will be panicked, I can assure you. The concern here is that the options that you have, such as going to general fund, that can come and go. And this fund, this program needs to know that the funding is there. That's why the dedicated sources were set up at the time. I think I'm one of the few people who was around at the time that this was established. It was an incredible achievement, but we don't want to see this achievement lost because the funding sources aren't there. You do have other options aside from general fund. You could increase some of the other assessments that are under the statute. I don't know that people would like that either, but I think the main focus that I have here is there's got to be a dedicated funding source. If we don't have that, a lot of people are going to get very frightened. Thank you. Aloha.
Thank you very much. Appreciate that. Anyone else here wishing to testify in this measure? Come on up, please proceed.
Aloha, Chair, Vice Chair, members of the committee, Kat Brady for Community Alliance on Prisons in strong support, and apologies for my extremely late testimony. We support this bill because families have become the invisibly incarcerated. I remember when 20 years ago, when I was getting bills from families, they were sending me their phone bills, $1,000 a month. You know, if they have kids, they want to talk to mom or dad before they go to bed. So the bills were absolutely outrageous for the people who could afford it, the very, very least. So the federal government just passed the Martha Wright Reed Just and Reasonable Communication Act. And that was good, but it needs help. We need a fairer market, because the prices of phone calls are actually set by the phone companies. And, you know, they're set by their whims. So that is a problem. By law, several states have actually changed and tightened the caps. So in Illinois, 7 cents per minute. In New Jersey, 11 cents per minute. But they also prohibit taking kickbacks, the state taking kickbacks from the company. California capped the rates at 7 cents a minute. Meanwhile, in 2020, Connecticut totally made their phone system free for people inside. This is a great reentry strategy. We need to keep families together and connected and loved ones connected. So we totally support this. And the general fund should be supporting Savin. Thank you.
Thank you very much. Anyone else here wishing to testify on this measure? If not, questions, members? Representative Ganadin.
To the Department of Public Safety. Check. I'm a little bit troubled by your testimony, noting that if we were to prospectively pass this, that you might just shut down phone communications.
That comment was made if we did not receive general funds
Okay, that sounds like the nuclear option. So I'm just
to cover free calls. The state of California, their legislative process or their budget covers the cost of all free calls. But again, with everyone else testifying, it's not a sure thing that we would get legislative general funding every year to maintain the system, as well as to pay for free calls.
Okay, all right. This bill has come before the legislature before. Did the Savin issue get resolved in previous drafts and in previous years?
This bill is the first time or the first year it's come through.
Okay, all right. Well, I'd just like to share with the committee, I'm a former staff attorney with the Domestic Violence Action Center, and of course a big supporter of all the work that you advocates are doing. And so I don't think any of us here wants to implicate some of that important work. But we are trying to think out how to prospectively move this bill. So what is the current company that the state of Hawaii uses for these services?
Through a competitive bid, we have Global Tel Link, known as GTL, or their new name is ViaPath.
Okay. And that's different from like the cell services that you or I probably use, like T-Mobile or AT&T or that kind of a thing?
Correct, because it's a fully automated system that monitors and records all inmate phone calls, unless it was identified as a legal call.
I understand. So does this contract allow for an expansion of communication like they're doing in the federal government, say emails, video calls?
This particular contract, no, it is only for inmate phone services. However, we have a separate contract that covers inmate tablets, where we are able to provide video visits as well as messaging, not emails, but the instant messaging and photo sharing, except we haven't turned those features on yet.
Okay.
That's in the next phase.
May I continue, Chair? I saw those tablets in person, I think, when I went to Saguaro last year. So is that what you're speaking about, the tablets that they have at Saguaro, or are these in statewide facilities?
No, Saguaro has their own. I don't know who their inmate phone company provider is. Yes, they do have their own tablets, but here in the state, we've launched our tablets as well.
Okay. Would you have to put out for bid a new contract to expand these services that the Oversight Commission and advocates are asking for?
Yes. It's because the only reason why we would do a competitive bid is because there's more than one company that offers these services, and we want to make sure that we are competitive with the pricing. So currently, under our contract, it's 7 cents per minute for the inmate phone call.
All right.
And that covers local, mainland, and international calls.
Okay. Is there any way without legislation to bifurcate the SAVN funding from the funding for inmate phone calls?
Currently, and the SAVN Governance Committee can correct me, but my understanding is that the special fund under SAVN is set up by statute, and the special fund is limited to receiving a 4% surcharge on inmate commissary purchases and the commissions derived from an inmate phone system. So those are the two.
I didn't know that. So in your mind, is it a more secure funding mechanism to pay for SAVN through the general funds or through purchases by inmates?
Through.
Which is, I guess, the system that you just described to us,
Through
like commissary purchases and essentially a tax. So do you think it's better if the state just outright pays for SAVN, or that it continues to like have this unique system of essentially taxing inmates to pay for a system?
I believe that if there was a mandatory funding mechanism for state general funds, as the previous testifiers had said, then the SAVN program would not be in jeopardy of being funded every year. And I'm not sure if that is possible with state funds. I don't think they can mandatory just say, every year it's this. I'm not sure. I don't know. So that's why the special fund was set up, because it was a annual deposit funding source for Savin.
Can we change, sorry, just one more, can we just amend the budget given to the Department of Public Safety in order to support Savin and support these increased communication capacity for inmates? So can we work with, you know, the finance committees to ensure that Savin is funded, or does it have to be paid for through what sounds like a tax on inmates?
I probably wouldn't be the best person to answer that, because it is a statute right now. So that would mean that a statute revision would be made, and the best person to answer the Savin questions would be Pamela Ferguson Bray, but she's not here today.
Okay.
Okay.
Thank you.
Okay, thank you very much. Any other questions, members? If not, thank you very much, all the testifiers on this measure. Let's go on to the next bill, House Bill 611, relating to agriculture, clarifies that customary and traditional subsistence farming, which is customary and traditional subsistence farming conducted by a native Hawaiian cultural practitioner in certain situations, is included as a protected activity under the Hawaii Right to Farm Act. First up, we have testimony from the State of Hawaii Office of Planning and Sustainable Development. Mary Alice Evans. Welcome.
Thank you, Chair, Vice Chair, and members. The Office of Planning and Sustainable Development supports the intent of this measure, but does offer an amendment. The amendment would carry out the intent of Chapter 226, which is goals and objectives, as opposed to being a self-enforcing statute. Thank you.
Thank you very much. Next, we have testimony and support from the Office of Hawaiian Affairs. And next, we have testimony and support from the Hawaii Farm Bureau. And testimony and support from the Hawaii Farmers Union United, Food and Policy Internship, Apoakea Native Hawaiian Innovation Institute, Will Karen, and Dana Keave. Was there anyone else here wishing to testify on HB 611? If not, questions, members? Seeing none, let's move on. Thank you. House Bill 982, relating to funding for the Department of the Attorney General Tobacco Enforcement Unit. First up, we have testimony in support from the Attorney General. Welcome. Please proceed.
Good afternoon, Chair, Vice Chair, members. My name is Rich Stacy. I'm the Unit Supervisor for the Tobacco Enforcement Unit. At the Attorney General's, I am a Deputy Attorney General. Thank you for hearing this bill. We are in strong support. This would stabilize funding for our unit. We are primarily funded through cigarette tax stamp revenue. This would slightly increase the fee that is attached to that to give us more revenue over the years. Last year, we had a decrease of 12.7%, and that we expect that's going to keep going. You may ask, the reason partially is that there are less cigarettes being sold, so that seems good. However, since that's the main part of our funding, we are still required to abide by the Master Settlement Agreement. The Master Settlement Agreement brings in payments to Hawaii. It's over $1 billion since it started. Last year we received $38 million, the year before $37 million. And part of us receiving that money is our unit diligently enforces what's required by the MSA. As the money goes down, if we don't have sufficient funding, we are at higher risk of losing the next arbitration. In the last year, Washington, Missouri, and New Mexico all lost their arbitrations. They faced a loss of tens of millions of dollars in MSA payments as early as this year. So we give 3 different mechanisms to stabilize our funding. We still have a carryover provision, so money that we don't spend carries back to the general fund at a certain level. So other than that, I'm available for questions. We appreciate your time.
Thank you very much. Next, we have testimony and support from the Department of Health.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Jill Thomas-Sherrill. I'm here on behalf of Director Fink of the Department of Health, and we just stand on our written testimony and support. Thank you.
Thank you. Next, we have testimony and support from the Department of Taxation.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Kathy Nee. I'm representing the Department of Taxation. Department of Taxation stands on its written testimony in support of this measure. We'd just like to note that the original effective date on the bill was July 1st, 2023. The department does note that it will be able to implement. We just wouldn't request that we would need time to work with the vendors and financial institutions to ensure that the fee increases for the stamp are properly implemented. I'll be available for any questions. Thank you.
Thank you very much. Next, we have testimony with comments from the Tax Foundation of Hawaii.
Yes, good afternoon, Chair and members of the committee. This is Jade McMillan for the Tax Foundation of Hawaii on behalf of Tom Yamachika, who submitted our testimony. We will stand on our written comments submitted for this measure. Thank you.
Thank you very much. Next, we have testimony in support from the Hawaii Primary Care Association, American Cancer Society, Cancer Action Network, testimony in opposition from Hawaii Smokers Alliance, testimony in support from the Hawaii Public Health Institute, testimony in opposition from Kathy Kim, Jessica Chang, and Dallas Nelson. Is there anyone else here wishing to testify on HB 982? Seeing none, questions, members? Seeing none, we'll move on. Thank you very much. Next, we have House Bill 1081 relating to penalties for unlicensed care homes. Clarifies the penalty to be assessed on any person who intentionally operates a care facility without a certificate or license. First up, we have testimony from the Department of Health in support. Is there anyone else here wishing to testify on House Bill 1081? Seeing none, questions, members? 1081, are you here? Nope, okay. So 1081, testimony from Department of Health, you've got it in your packet. So we're on House Bill 1081, Department of Health.
Thank you very much. Keith Ridley, Chief of the Office of Healthcare Assurance on behalf of the Director of Health.
You came in right on time.
Oh, fantastic. Thank you. I'm monitoring another bill that's on the other committee.
Thank you. Please proceed.
The department stands in strong support of this administration bill. Essentially, this is a housekeeping bill where there are conflicts between two statutes. So we're asking for one statute to be repealed to avoid conflict with another statute. The one that we're asking to be repealed is HRS Section 321-486.3, and the one that we're in favor of is HRS Section 321-20. Thank you very much. I'm available for questions.
Great, thanks very much. Okay, now, any questions, members? Representative Gannon?
To the Department of Health, if you have a moment. Sorry.
No, it's good.
Yeah. Licensure of care homes comes up often in the community I represent in Lower Kalihi. How often does the department have to impose these kinds of penalties?
We have, most of these penalties that we are imposing are on unlicensed care homes. We currently have a list of about 150 to 175 complaints on unlicensed care homes that we are currently investigating or where the investigation is pending. To date, we have issued notices of violation and orders to a couple of dozen homes, most of them for unlicensed activity, and we use 321-20 as the means of addressing the remedy for those homes.
Is, I see Representative Mizuno, who we have a shared interest in ensuring that the state appropriately regulates these homes and ensures these things. My concern, of course, is that the cost of housing is so high throughout our state, and especially here in urban Honolulu, that licensure sometimes becomes difficult for families or individuals who need to pay for a care home. What happens if these fines are imposed upon an unlicensed care home, and then someone might become houseless or something? Is there a way for the department to interject into that process, like so that people don't become houseless as a result of finding themselves in an unlicensed care home?
Well, Chair, if you would indulge me, there are 4 criteria that we look for when we investigate an alleged unlicensed care home. That the home is providing 24-hour accommodations to someone not related to them who requires care for a fee. Those are the 4 things we look for. Now, if we find that evidence when we go into a home, then we issue a notice of violation order, a NOVO, for the home to cease and desist and to transfer the residents being cared for to a licensed home. And they also have appeal rights. So, the operator will usually appeal the process. During the appeal, everything is stayed, so the residents continue to reside there at the home. The concern is ensuring that frail and elderly and vulnerable persons are being well taken care of in a licensed facility rather than an unlicensed home. We understand the concern about potential homelessness. That is not our intention. Our intention is to ensure that those frail and elderly and vulnerable persons are receiving quality care.
Thank you.
Thank you very much. Other questions, members?
Chair, I had a question.
Yes, of course.
Thank you.
Representative Mizuno.
Thank you. Mr. Ridley, thank you for being here. We've heard stories over the past several years of these illegal, unlicensed care homes charging $8,000, $15,000 per private client, some making $40,000, $50,000 a month. We don't know if they're taxed because they are not certified or licensed by the Department of Health. Department of Health, you can't do an unannounced visit. You cannot do annual inspections. There's no criminal background check that the legal care homes have to go through. No fingerprinting, no liability insurance. And I do know that you have closed, I've seen the press releases before, you have closed down a number, not you, but Department of Health, closed down a number of these illegal care homes. Again, if they're making $50,000, $60,000, $70,000 a month, they have the best attorneys defending their cases. But if a care home, illegal care home is closed down, my understanding was that Department of Health works to get those patients into a legal, licensed, certified care home. Is that correct?
That's correct. That's part of the order, that they cease and desist operations and that they immediately transfer or discharge the persons that they are caring for. As I mentioned, they do have appeal rights, and during the process of the appeal, everything is stayed, so the residents continue to stay there. The penalties that are allowed in HRS Section 321-20 are on a per-day basis. So as you mentioned, those who are making tens of thousands of dollars a month, this fee, this assessment of $1,000 per day really adds up. And it really gets the attention of the particular ones that we're issuing NOVO on, as well as we hope others who also see the press releases. But we know that some of them are registered as a business. We know that, or we suspect that some of them are paying their taxes to the Department of Taxation. But when we do find these homes, we work with the Department of Taxation for them to conduct potentially any investigation on whether in fact taxes are being paid on their income.
Right, and last question, Mr. Chair. I know this is a penalty bill, but I believe it's also a consumer protection bill because we need the Department of Health to certify and license these care homes. And on a drop of a complaint, have the ability to do an unannounced visit, just like all the legal licensed care homes need to abide by. Is that correct?
That's correct. We're in the business of ensuring that the licensing process is maintained in order to protect the frail and elderly and aged individuals.
Right. Our most vulnerable consumers are kupuna and disabled. So, Mr. Chair, thank you very much. Thank you, Mr. Ridley.
You're welcome.
Thank you very much. Any other questions, members? Seeing none, we'll move on. Thanks very much. Okay, our last bill on the agenda today, HB 1442, relating to rehabilitation, expands the criminal justice diversion program, amends the allowable period of court-ordered assisted community treatment and considerations for extensions, allows courts to require certain probation violators to undergo mental health evaluation and treatment as a condition of continued probation, and requires DOH to contract with behavioral health crisis centers and appropriates funds. First up, we have testimony from the Attorney General.
Good afternoon, Chair
Afternoon.
Tarnas and Vice Chair Takayama, members of the committee. I'm Deputy Attorney General Albert Cook, and we thank you for the opportunity to provide comments on this rather expansive bill. Generally, the department agrees with the goals to get mental health treatment for those in the criminal justice system and to protect the public by decreasing recidivism by defendants who are mentally unfit. However, the department opposes expanding the Act 26 diversion program, which is a diversion program for criminal defendants, because the program has not stopped recidivism. I've cited some statistics in our testimony, and I think the Honolulu prosecutors actually has more specific statistics. And it's also unclear if those who are diverted from criminal prosecution actually get any meaningful mental health treatment. The department also opposes releasing defendants on conditions while awaiting placement. We have concerns about some of the proposed changes to the commitment process, and we oppose reducing the prosecutor's role in determining placement of defendants into the diversion program, as well as we have serious concerns about requiring the defendant's agreement to be placed into the program, whereas by definition, the people who are being placed in the program are not mentally fit to make even legal decisions about their cases. So requiring their consent to enter the program seems problematic. So our written testimony provides more detailed analysis, and will be available for questions, if any. Thank you.
Okay, thank you. Next, we have testimony from the Office of the Public Defender.
Good afternoon once again. William Benza, Deputy Public Defender. We support the bill with one exception, and that is the part that deals with probation. The idea that you can amend a person's terms or conditions of probation and add on the requirement for a mental health assessment and treatment seems to make sense. But to be able to revoke a person's probation because they've not followed through with that treatment or have been determined not to benefit from that treatment seems quite unfair, because that means that the person, and as it's written, shall be incarcerated. So an individual in that situation, solely based upon their unsuccessful attempt at mental health treatment, can be revoked and incarcerated. People who are involuntarily committed in a civil process can't be held at the state hospital unless they're mentally ill and a danger to themselves or others. At the very least, I think, we should amend this part to reflect that it shouldn't be the sole reason why a person is revoked or incarcerated if they're suffering from mental illness. If there's evidence that they're posing a danger to themselves or others, perhaps that could be considered, or if they violated any other term or condition of their probation. But as written, it's not taking that into consideration. Thank you, and I'll be available for any questions.
Thank you very much. Next, we have testimony from Brandon Kimura of the Judiciary. Next, testimony from the Hawaii Correctional System Oversight Commission. Welcome.
Martha Torney again, and I think this committee is well aware that nationwide jails have become the de facto mental health and homeless facilities for states. This is an ongoing problem. People that really fill up our jails are often those that are frequently arrested and detention of persons who are unsheltered, have substance abuse disorders, or are mentally impaired, or a combination of all the above. This is a very complex issue, and I know it's not going to be a simple solution, but we have to pay attention to it. So we do support this measure as one way to start paying attention to it. It's going to take a lot more. Thank you.
Thank you very much. Next, we have testimony from the State Department of Health.
Michael Chapin.
Come on. Everybody online and throughout the building need to hear your voice.
Thank you. Michael Champion from the Department of Health. We stand on our written testimony in support.
Thanks very much. Next, we have testimony from the Honolulu Police in support. And we have testimony in support from the Hawaii Substance Abuse Coalition, from the Institute for Human Services, testimony in support from Juanita Kawamoto Brown, testimony in support from Will Karen, and testimony in support from Dana Kiave. Is there anyone else here wishing to testify in this measure? Please, come on up, sir.
Chair, Vice Chair, members of the committee. I apologize for our late testimony. Deputy Prosecuting Attorney Mark Tom for the department. The department opposes House Bill 1442 in part. However, would note to the committee, we do support parts of House Bill 1442. First and foremost, the department supports any mechanism, strategies to ensure treatment for individuals that are seeking it. Unfortunately, the department does not believe Act 26 as constructed provides effective treatment to ensure individuals are stabilized before being released back into the community with their cases dismissed. Based on our research of all the individuals that come through under Act 26, approximately 85% of those individuals are rearrested. That's data pulled from the Criminal Justice Information System, which is CJIS. And of nearly all of the individuals that came through Act 26 also had at least one police contact after they were released from HSH under Act 26. And when I say a police contact, it could be as MH1, which is their individual is on the street having a mental health crisis, officer comes, does not cite them, does not arrest them, but tries to transport them to a medical facility to get treatment. Another thing that we also oppose is the removal of the prosecution and the decision-making process of diversion. The reason is, in our office, we practice vertical prosecution. We have one deputy that covers mental health court. That deputy has been doing it for 20 years. And they have institutional knowledge that provides from judicial determinations from prior years of history of these individuals that are very important for determining fitness, dangerousness, and whatnot for individuals. If knowing the goal for the collective stakeholders is not to just rush individuals in and out of the criminal justice system, especially unfit individuals, we want to make sure, the department wants to make sure we stabilize and ensure that they have long-term treatment and support. So we're just asking to pump the brakes on expansion at this time, but revisit and look at the bill and see how we can provide mechanisms to provide better structure, get a handle of it, make sure the project is moving forward successfully with petty misdemeanor, nonviolent offenses, and then maybe approach expansion in the future. We'll be here for any questions. Thank you.
Thank you very much. Is there anyone else here wishing to testify on HB 1442? If not, questions, members? Representative Gannon.
Sorry.
No, no apologies needed. I was just checking to see if anybody else wanted to speak first.
Mr. Tom, from the Office of the Prosecutor, Honolulu First Circuit.
HGs are here too.
Yeah, I know.
Just joking.
No, because we're friends. I want to ask questions of you. It sounds like it might be helpful to get another position to assist with the potential passage of this bill so that we can assist individuals who are adjudicated unfit by the court to receive the services that they need. Do you think that that would be appropriate?
I definitely, the department, I will say this, we support trying to get effective treatment. And that might be, that might be ensuring that we have the facilities. And so we support any appropriation to get more beds, more facilities, more places that individuals can be maybe housed a little longer than 7 days before they're just cut loose as being unfit. It might be something like 30 days just to stabilize. And if we do not have the bed space, we don't have the facilities, the department is in full support of trying to get that full, to get proper treatment.
Okay. How does this bill differ, maybe the Office of the Attorney General might help, from the already in place mental health specialty court?
How does?
Yeah, that might be best answered by the Office of the Attorney General.
Can't hear you. Come on up.
So apologies.
And again, I'm limited in my official testimony from the Attorney General to what's in my written testimony, but in my personal capacity, I've been a prosecutor for about 25 years. So my understanding of the mental health court is that it's mainly for felonies, and it's a different procedure. This is a program that, it's mainly, at this point, just for petty misdemeanors, nonviolent. And my understanding, and correct me if I'm wrong, is that they come in, they're found, or they're referred to the program, they're found unfit, then within 7 days, they're evaluated. Usually, if they're continued to be found unfit, the criminal prosecution is dismissed, and then HSH generally will cut them loose. And we're not sure whether any mental health treatment occurs at that point. I think what HSH does is they give them a name of a peer counselor or a counselor, but as to whether or not any of these people actually go to the counselor, I don't know if we have statistics on that. So I think the AG's position and the prosecutor's position is that at this point, we're not convinced that Act 26 is working to actually get treatment to these people and to keep them from committing new crimes, because according to the prosecutor's statistics, most of them have come back like multiple times. So at this point, expanding the act might be premature, as it doesn't seem like it's actually working.
Just to add to that, Rep, I think what Albert's talking about is mental health court.
Microphone.
Oh, mental health court in circuit court, but we also have mental health court in district court as well. So what happened in Act 26 is a lot of times our deputy, who obviously has been practicing and doing mental health court for 20 years, had the ability to at least move for civil commitment when there was a possibility of dangerousness or some concern for this individual. But under Act 26, if an individual comes in for a specific type of act, and that is nonviolent petty misdemeanor offenses, but over past history, they might have been judicial determination of dangerous, they are not allowed to move for civil commitment. So that is a big difference under Act 26. It doesn't preclude the Attorney General's, but it's a very strict standard. It's imminent dangerous to individuals or to themselves. So that kind of changes the structure of how our deputy proceeds forward in mental health court at district court level.
Mr. Tom, I think I'm just concerned with your testimony noting that, you're in support of the idea of this, and you are in agreement with the Office of the Public Defender in theory, and other members of the government. However, the Office of the Prosecutor is still not supporting the expansion of Act 26 under this bill. So I'm wondering if there's more resources that the state or the county can give you to assist with this transition towards diverting individuals to mental health treatment.
And so just to clarify, we're not coming in here and saying this Act 26 is obviously our research is 85% are being rearrested, scrap the whole program, get rid of it. There's nothing we can do to fix it. In that sense, the department does support trying to move forward and finding mechanisms to tighten it up, make it a stronger program. So we're not opposed to trying to get treatment under Act 26. We're just concerned that we're moving too quickly. And I understand it's from 2020, it's 2 years. But when collecting the data, there might be some discrepancies that we need to work out before we start just expanding it to nonviolent misdemeanor offenses. And in parts of this bill, opens it up to, not under Act 26, but under penal responsibility, opens it up to any types of felony cases as well. So I think taking a step back, kind of taking a look at the data with all the stakeholders, I think we all have the same goal of getting treatment. I think it's just figuring out how to get to that goal. And we also have to look out for victims. And when a case is dismissed, those victims have very little recourse now. And a lot of these are property crimes. So we also are looking at a lot of different variables that we're trying to anticipate. So we're not saying close out the program, just reevaluate it. Don't expand at this point until we have sat with the stakeholders and try to figure out how to make this work for nonviolent petty misdemeanors.
Thank you.
Thank you.
Chair.
Is it another individual? I don't know. And
Dr. Champion.
Somebody else wanted to.
Yeah.
Representative Mizuno, go ahead.
Thank you, Chair Tarnas. Department of Health, Dr. Champion. If you can help me with my memory, believe early on we had an informational briefing on this exact subject. And Dr. Champion, I think Department of Health did share some statistical data. Could you enlighten this committee on what we found regarding rehabilitation for nonviolent crimes, petty misdemeanors, nonviolent petty misdemeanors? If you could educate us again on the success rate.
Yes, so thank you. I'm Michael Champion, a medical director for the Adult Mental Health Division in the Department of Health. And Representative, if I may, on the way to addressing that question, if I may go back to the difference between mental health court and Act 26. So both are diversion programs, diversion opportunities to take folks who have a mental illness or behavioral health condition and divert them from the criminal justice pathway. The mental health court that we have in district court, available in circuit court, is a diversion opportunity downstream in adjudication. Act 26 is designed to address the dilemma that we have in this country, in this state, of a flood of individuals coming in with mental illness and being before the bench and having mental health needs and being unfit to proceed, or they may be unfit to proceed and need an evaluation. Hawaii is like other states in the nation where this big influx has a huge impact on court processes and also the mental health system. Other states have long wait lists for all levels of crimes where people are waiting in jail to get their evaluation. Here in Hawaii, due to a federal court injunction, there's not a wait list to go to the state hospital. Once somebody's found unfit, you go right away. But there can be a wait for a evaluation of fitness, even if you have a petty misdemeanor. So, to the data, Act 26 is designed to flag an individual where they're suspected of not being fit to proceed, and on a screening evaluation found to likely not be fit. Go into the state hospital for 7 days, be evaluated, committed to the hospital through a civil commitment if needed, if they meet that criteria, and if not, linked and synced with resources in the community. And so I think the data point that is extremely important is that individuals with these minor crimes, instead of waiting 55 days in jail waiting for mental health evaluation to even determine whether they need mental health services, instead are sent directly into the Act 26 program and are getting evaluated and treated within 2 days. So I think that's a significant thing from a clinical standpoint to look at. Does that answer your question, Rev?
Yes, follow-up question, Chair, if I may.
Okay.
So, Dr. Champion, and so again, just hypothetically, I'm the person that gets checked in, but it's more than 2 days. If I need support group, support services, you're there to provide that, and so chances for me committing recidivism, committing another crime again, are low. And the statistical data I think that you indicated was rather high, maybe a 70-80% success rate, if I remember correctly.
Yes, there's different data. The 80% rate of success that's noted in the judiciary's testimony is for those individuals who have gone the Act 26 pathway. 80% only had that one time in the Act 26 program. The prosecutor's office has cited other data about recidivism with new crimes. And I think as we all move forward, looking at the best way to divert people, when appropriate, out of this justice pathway, it's important to look at both sets of data. We can only go together on this to have success.
Thank you, Dr. Champion. Thank you, Chair.
Thank you very much. Any other questions, members? Nope. Seeing none. Thank you very much to all the testifiers today. That completes our hearing of the bills on our agenda. Just so people are wondering, we already voted on the last bill on our agenda at the very beginning of this hearing. So we can now move on, and we'll go back to the top of the agenda, and we'll move directly into decision making. House Bill 1128, relating to support for traditional native speakers of Hawaiian. After consultation with the Education Chair, we're going to move forward with an HD2 with just some technical amendments, changing new speakers' parents should be changed to parents who are new speakers. Native speakers and new speakers should be defined, and we need to correct some of the section numbers and make some other technical amendments. I'm going to put in the standing committee report that the request is for $50,000 to the Public Charter School Commission to do the work that's outlined in this bill. With that, HD2 recommendation, questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1128 HD1 with further amendments. Chair and Vice Chair vote aye. Representative Ganadin.
Aye.
Representative Holt.
Aye.
Representative Hashimoto.
Aye.
Representative Ichiyama. Excused. Representative Iligan.
Aye.
Representative Kong.
Aye.
Representative Mizuno.
Aye.
Representative Souza.
Aye.
Chair, your recommendation is adopted.
Thank you. Let's move on to the next measure, HB 1508. I'd like to adopt the recommendation of the Attorney General. They've suggested wording to appropriate funds to the departments for purchase of service. I would use what they've drafted here, but remove the appropriation amounts and put that into the Standing Committee report, and defect the effective date to 6/30/3000. Is there any questions or concerns with that recommendation? If not, Vice Chair for the vote.
Voting on House Bill 1508 with amendments, noting the excused absence of Representative Ichiyama. Anyone wishing to vote WR or no? Seeing none, Chair, your recommendation is adopted.
Thank you. Moving on to House Bill 1430, relating to the University of Hawaii at Hilo. Recommendation is to move it out as is. Members, questions or concerns? If not, Vice Chair for the vote.
Voting on House Bill 1430 HD1 passing as is, noting the excused absence of Representative Ichiyama. Anyone wishing to vote WR or no? Seeing none, Chair, your recommendation is adopted.
Thank you. House Bill 1157. The Office of Information Practices said they prefer Senate Bill 719, which is scheduled tomorrow for a vote. And just as a reminder, we already passed a House bill that included appropriations for the 2 positions in OIP. So I think we're covered in terms of the positions with the House bill. If OIP prefers the Senate bill, my recommendation is to defer HB 1157, and then we'll work with the Senate bill when it comes over. That's my recommendation. Thank you very much. We'll move on to the next measure, House Bill 1037. My recommendation is to pass out with an HD2 with some technical non-substantive amendments. Any questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1037 HD1 with further amendments, noting the excused absence of Representative Ichiyama. Anyone wishing to vote WR or no? Seeing none, Chair, your recommendation is adopted.
Thank you. House Bill 1385, I would like to move on an HD2. I know that there are some concerns with DLNR and that they're actually actively pursuing possible collaboration with the Hawaii Community Development Authority, which is in another bill. I would like to move this forward for continued discussion. I would like to make some amendments, some technical non-substantive amendments. I would like to put the appropriations that are in the bill, delete those, but put them into the Standing Committee report. We have to clean up a couple different parts of the bill and align the timeline so that it's not as confusing. I would recommend that, for example, we require the board to submit the plan to the legislature no later than 20 days prior to the convening of the regular session, immediately following the submission of the plan to the board. We will make consistent the language on in 2 different parts of the bill that are currently inconsistent. Page 13, line 16 to 20, and page 10, line 14 to 19. With those recommended changes, my recommendation is pass out an HD2. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1385 HD1 with further amendments, noting the excused absence of Representative Ichiyama. Anyone wishing to vote WR or no? Seeing none, Chair, your recommendation is adopted.
Thank you. Moving on to House Bill 921. This bill really needs a lot of work, and we're not going to be able to fix it in here. I'm going to request that the introducer work with the Chair of Energy and Environmental Protection, with the Attorney General and Department of Health, and come back with a bill that actually can work, because right now it doesn't appear to me that it's very workable. So I recommend that we defer this measure. Next, moving on to House Bill 277. This bill, I'm going to move forward with an HD1, defect the effective date. I'm also skeptical about increasing fines for violating motor vehicle insurance requirements, but the introducer of the bill has really requested that we continue discussion on it, so I will acquiesce and move forward with an HD1 defecting the effective date. It still has blank amounts in there for increasing the fines. With that recommendation, questions or concerns, members? If there's no questions or concerns, Vice Chair for the vote.
Voting on House Bill 277 with further with amendments. Anyone wishing, noting the excused absence of Representative Ichiyama. Anyone wishing to vote WR or no?
No.
No vote for Representative Ganadin.
With respect to the introducer.
Representative Kong.
No vote.
A no vote for Representative Kong. Chair, your recommendation is adopted.
Thank you very much. I understand your concerns, and I completely understand why you voted no. Okay, let's move on to the next bill, HB 824, creates a medical release program for Department of Public Safety. I'd like to move forward in HD 2 on this one. Let me pull up my notes here. I would like to adopt some amendments recommended by our House Majority Staff Office, basically clarifying that the statutory language for the program explicitly established the requirement that the medical release program is for certain inmates who pose a low risk to public safety, because that language is not in there. I also want to make some technical amendments. There's a couple of definitions, continuity of care and medical release plan, that are not used in the new subpart, so we don't need those. And then on page 7, line 17 through page 8, line 2, the sentence and its proviso are contradictory. So we'll have to clarify whether the revocation of an inmate's medical release may be used as a factor in determining eligibility for future parole or release. So we'll make that clear. And we'll make some technical amendments. And also, I would like to defect the effective date, and I'd like to adopt the Department of Public Safety's amendments on page 4 of their testimony, so that we would add when the request is accompanied by request for medical release may be initiated by the director, an inmate, or an inmate's representative when the request is accompanied by the recommendation for medical release by a physician who is licensed to practice medicine in the state of Hawaii. And then adopt the recommended amendment on page 5, that we delete the modification of subsection G so that it's in compliance with legal processes and requirements. And then on page 6, I would like to take what they've included here, which is the staffing requirement, 2 FTE staffing requirement, 1 physician and 1 advanced practice registered nurse, and the dollar amount, $368,996 per year recurring, I'd like to put that into this standing committee report while it's blank in the bill. So move it out with an HD2 with those amendments. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 824 HD1 with further amendments, noting the excused absence of Representative Ichiyama. Anyone wishing to vote WR or no? Seeing none, Chair, your recommendation is adopted.
Thank you. House Bill 1133. While I really would like to have free calls, voice communication from our correctional facilities, I also do not want to jeopardize the funding to Savin, so we're stuck between a rock and a hard place on this one. In discussions with the chair of CMV, he also recognizes that this needs more work, and he has committed to working with the parties to come back with a recommendation. If we were to go to the general fund, it would cost about $2 million annually to pay, that's an estimate that we have, to pay for the free phone calls. And we would have to appropriate $400,000 annually to the State Automated Victim Information and Notification Program. CMV chairs says we just need to work on this more. So I would like to take the CMV chair up on that and ask him to go back and work on this with the interested parties. And in light of that, I would recommend deferring this. That's my recommendation. Next, moving on to HB 611, related to agriculture. I would like to move out an HD2. I would like to incorporate the amendment recommended by the Office of Planning and Sustainable Development and the recommended amendments from the Office of Hawaiian Affairs. OPSD wants to just modify one portion of the State Planning Act so it's consistent, to read perpetuate the practice, and I want to use the Office of Hawaiian Affairs definition of customary and traditional subsistence farming. So we would replace the definition that's in the current HD1. So with those changes, I would like to move on an HD2. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 611 HD1 with further amendments, noting the excused absence of Representative Ichiyama. Anyone wishing to vote WR or no? Seeing none, Chair, your recommendation is adopted.
Thank you. House Bill 982, I would like to move this out as is, but in the Standing Committee report, I would like to include the language that is in the Attorney General's testimony, $750,000 in Section 2 and $750,000 in Section 4, and an effective date of July 1, 2023. That's my recommendation. Any questions or concerns, members? As is with those in the Standing Committee report. If not, Vice Chair for the vote.
Voting on House Bill 982 HD1 passing as is, noting the excused absence of Representative Ichiyama. Anyone wishing to vote WR or no? Seeing none, Chair, your recommendation is adopted.
Thank you. Moving on to House Bill 1081, very important measure. I'm comfortable with the language as it is, so my recommendation is to pass this out as is. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1081 HD1 passing as is, noting the excused absence of Representative Ichiyama. Anyone wishing to vote WR or no? Seeing none, Chair, your recommendation is adopted.
Thank you. Final measure, HB 1442, relating to rehabilitation. This is a very important measure. I recognize that the Attorney General has got serious concerns with this, and the prosecuting attorney has serious concerns with it, but we've got to move in this direction. We've got to figure out a path forward on this. I would like to move out an HD2, incorporate the public defender's recommendation, address the concern that the public defender has in their testimony by changing the word shall on page 27, line 19 to may. So it's not a requirement that the probationer be subject to revocation of probation and incarceration if the probationer does not comply with the orders of an evaluation and treatment, or it's determined that the probationer cannot benefit from suitable treatment. I want that to be may, not shall. I would like to put in the Department of Health, they've got recommendation for the to make it clear that this committee acknowledges the need for locations that will have an increased number of evaluations to be fully operational prior to program implementation, and include in the standing committee report the estimated staffing requirement of 5 FTE court-based clinician positions at a cost of $575,000 annually, and that the start date for the measure would be no sooner than July 1st, 2024. I know that the Attorney General and the prosecuting attorneys still have serious concerns. I would like them to keep working with us to figure out how to move forward, because frankly, I don't want to send somebody that's got residue in a pipe to prison. It's a mental health, it's a substance abuse issue, and I want to get them help rather than put them in prison. So with that recommendation, I would like to move out HB 1442 with an HD2 as I've described. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1442 HD1, further amendments, noting the excused absence of Representative Ichiyama. Anyone wishing to vote WR or no?
With reservations.
Reservations noted for Representative Collin. Chair, your recommendations adopted.
Thank you. I appreciate everyone's forbearance with this. There being no further business before this committee today, we are adjourned.